I noticed that during Ms. Linskog's presentation before the court, you were smiling quite a bit. I don't know if you were particularly entertained, but this court doesn't see anything funny or entertaining about the situation currently before the court. Darren Butericos and Aaron Butericos, plaintiffs versus Slab Estates LLC, Costa Butericos, and Braxton Byfield, defendants. Ashlyn Linskog appears on behalf of plaintiffs. Joshua Alvin appears on behalf of defendants. This matter comes before the court at this time for further proceedings in regards to the plaintiff's motion for a preliminary injunction that was filed in this case. I've become recently aware that the defense has filed a response to such motion in the case. I do have that available to me at this time, counsel. Ms. Linskog, you may proceed further in pursuit of your motion at this time.
Yes, Your Honor, thank you. I'd like to let the court know that it appears both plaintiffs are also present in the Zoom hearing. I did also have a chance to review Mr. Albin's filing as of yesterday, and so most of my argument for you, Your Honor, will just be sort of addressing the points made in that filing. Big picture here, Your Honor, and thank you for taking the time this afternoon to get in front of us. The reason that we asked for such a quick setting is because there is a sort of sister case in the Butler County District Court with Judge Murfin. An eviction action was filed. We had a hearing, a preliminary hearing in that.
All right, guys. Today, we are jumping straight into a courtroom moment that instantly turned tense. What started as a normal hearing suddenly shifted when the judge noticed the defense attorney smiling during a serious argument. Instead of ignoring it, the judge directly called him out in front of everyone, making it clear that this case was no joke. That one warning immediately changed the atmosphere in the courtroom and set the tone for everything that followed.
Last week, the plaintiffs in this case, or the defendants in this case, are represented by different counsel in that case, but ultimately, they are seeking the eviction of Aaron Buterakis from the premises. And so we had explained to Judge Murphy that we would be seeking injunctive relief from this court and filing this petition. Your Honor, the best that I can describe what is happening here is that the defendants in this case, both through the LLC and personally, are essentially trying to use an eviction shortcut over a disputed ownership property situation, which I think Kansas law very specifically addresses. And that's why we're here, Your Honor, is to stay those particular proceedings as it relates to the eviction until those underlying property rights can be determined under our initial petition in this case. We believe and would submit to the court that defendants are misusing the eviction process. They rely on, in reviewing Mr. Albin's response and having been present at the court hearing, they rely on the idea that there is no contract. So therefore, we're not under the Contract for Deed Act. But that just isn't the case, Your Honor. For context, Mr. Buterakis, Aaron Buterakis, lives in the home with his partner and minor child. They have been living in the home for quite some time. They have been the ones paying defendants the monthly installment payments that were put into place. So the status quo as it exists right now, Your Honor, is that my clients remain in possession of the real property. Defendants' initial argument in response to our motion was that because no executed contract exists, that is a mouthful, that we're not under the Contract for Deed Act. First, Your Honor, I believe the defendant's argument is contradicted entirely by the March 2025 contract for purchase and sale of real estate. It was executed by both defendants and Mr. Darren Buterakis and his wife, Dawn Buterakis, who are the parents of Aaron and one of the defendants, Costa. That is an agreement to sell the property. That agreement expressly on its face contemplates seller financing. This is Exhibit A, Your Honor, that we filed, but paragraph 35 expressly contemplates an owner-carry financing arrangement with an interest rate in over 28 years, payment terms, confirming that the parties did initially agree to a seller finance structure as opposed to a third-party mortgage or a third-party financing loan. An owner-carrier arrangement necessarily involves payment over time. And this contract on its face that was executed by all the parties otherwise indicates that that was always the plan. One of the arguments Mr. Albin makes is that the Contract for Deed Act presupposes an existing contractual relationship. So if I understand that right, the position is that the contract that my clients aren't entitled to contract for deed protections because they don't have what Mr. Albin and defendants would describe a fully enforceable contract. In support of this position, Your Honor, they cite a case from 1988, which is approximately 36 years before the Contract for Deed Act went into effect, which was in 2024. What I believe the defendants are missing here, and what I attempted to explain at the eviction hearing, is that under KSA 58201, a contract for deed is defined as an executory agreement in which the seller agrees to convey title to real property and the buyer agrees to pay the purchase price and 5 or more subsequent payments while the seller retains title as security. Your Honor, that's exactly what the initial real estate purchase contract states. That's what the conduct between the parties over the last year has indicated. And specifically, an executory agreement is one which material obligations remain to be performed by both parties. The legislature didn't say a contract that is very clearly outlined and executed that is called a contract for deed. I would submit to you that that was done on purpose because the statute requires an agreement to transfer title. It doesn't require that title has already been transferred or that the mechanism is very perfectly documented. It just requires the defining features that the seller keeps title until payment is complete. In this case, my clients, Mr. Darren Budarakis, and then his wife, who is not a party to this case, which I'm happy to give the court context to, paid $40,000 in cash to the defendants in this case. They haven't accounted for that $40,000. They didn't offer to return the $40,000 during the eviction proceedings. But I don't understand there to be a dispute that the $40,000 was received. Beyond that, there's no dispute between the parties that the plaintiffs had made ongoing monthly payments. That is reflected in Exhibit D of the documents that we presented to you, Your Honor, which is called the Catch-Up and Transfer Agreement.
In this part, the plaintiff's attorney lays out the heart of the entire dispute. She argues that the defendants are trying to use eviction laws as a shortcut to remove a family from a home that was allegedly being purchased through a long-term seller-financed deal. The courtroom gets more intense once she reveals a claimed $40,000 cash payment along with ongoing monthly payments. According to her, this was never a rental situation, but a real ownership agreement disguised as something else.
Again, the mere existence of a catch-up and transfer agreement presupposes that an ongoing payment obligation was tied to ownership, not rent. Those payments have been accepted as recently as, I believe, April 1st. No, I don't understand, or maybe in March. Maybe the last payment was made in March. I see Mr. Albin shaking his head, and I don't want to misspeak, but I know the March payment was made. Our position here, Your Honor, is that defendant's argument as it relates to this would require the court to ignore the economic reality of this transaction. It is not a landlord-tenant situation. It's a purchase relationship. Whether the agreement is perfectly defined is a merits issue. But what matters here, Your Honor, at this stage is that there's a substantial dispute as to the nature of the transaction, and we would submit to you that the eviction proceeding is not the appropriate mechanism in which to resolve these ownership disputes when the Kansas Contract for Deed Act gives us the mechanism in which this should be done. Next, defendant's response argues that plaintiffs cannot establish an equitable ownership in this case. That argument focuses on equitable ownership, again, under pre-Contract for Deed Act case law. That's not the controlling framework that we have to use here, Your Honor. The Contract for Deed Act governs the rights at issues here. Under KSA 5204A, it states that a buyer's rights under a contract for deed shall not be forfeited or canceled except as provided in the section. That statute is designed to protect a buyer's rights in this exact scenario, that their equitable interest cannot be forfeited or canceled except as provided under the statute. It doesn't condition those protections on sort of some predetermined equitable ownership determination. Here, defendants rely on the 1954 Murphy case and the 1946 Peterson case, which addressed when equitable ownership may be recognized under common law. But the Contract for Deed Act, obviously, is the more recent and addresses the situation we have here. The legislature has provided the statutory scheme to allow for these types of situations to be heard in equity, and to make sure to protect buyers under contract for deed situations, to make sure that they're not evicted from property that they otherwise thought that they were gaining an equitable interest to. Under 585204, that's the section I just cited, where it talks about the only way in which a buyer's equitable rights under a contract for deed can be forfeited or canceled. The seller has to give notice of default and the buyer's intent to forfeit. They have to specify what terms were breached, what must be cured. They have to do the same thing that mortgage companies have to do, depending on how much time, how much has been paid as it relates to the total amount, how much time that the buyer has to sort of redeem or cure, and they have to serve notice properly. The defendants in this case did not engage in any of that conduct under the statute, Your Honor, presumably because they've taken the position all along that statute does not apply to them. But as opposed to giving any notice to the buyers in the contract, which are Darren Budarakis and Don Budarakis, they elected to instead attempt to regain possessory rights by evicting Aaron and his partner and their young child, who have expressed permission from both defendants and from Darren and Don to be in possession of the property. Also, Mr. Albin argues in his response that incites to the fact that payment alone is not enough to create an equitable interest here. Your Honor, again, plaintiffs aren't relying on payments alone, although the record does reflect significant payments, possession, and an ongoing purchase arrangement that has been historically acknowledged by defendants. But the Act doesn't require my clients at this stage to prove equitable ownership before the protections offered to them under the contract for deed apply. It just exists to ensure that buyers who are in the exact situation that Mr. and Mr. Budarakis are in are not stripped of their rights before those equitable determinations, or before those rights can be determined by this court. Defendants further allege that Aaron Budarakis, who is in possession of the home and is living in the home, doesn't have standing to participate or any enforceable interest in this case. Specifically, the Contract for Deed Act defines a buyer as a person who purchases property subject to a contract for deed or any legal successor in interest to the buyer. As this court is probably aware, a successor in interest is someone who acquires rights or steps into the buyer's position in whole or in part. This can happen through an assignment, a transfer, or some type of course of dealing. The Act does not say and does not require that a documented and perfected and notarized court-approved assignment is the only mechanism in which a successor in interest exists. Here, both defendants were aware that Aaron was residing at the property. Both defendants accepted payments while Aaron was residing at the property. And both defendants were put on notice by Darren Budarakis, who is a buyer to the contract, that he intended to assign his rights, any rights that existed in this property, to Aaron. That has been made abundantly clear. There are written text messages between the parties that evidence this. So our position here is that at minimum, Your Honor, there is a dispute as to whether Aaron is or is not a successor in interest, but that dispute is not appropriately handled in an eviction proceeding. That position would essentially allow them to accept payments to permit him to reside there and then deny that he has any rights or that the Contract for Deed Act would otherwise apply to him. There's some argument in his response as it relates to marital property and that somehow eradicates any interest that Aaron would have or as a successor in interest. I would submit to Your Honor that to the extent those issues regarding marital property.
Now the legal battle gets even deeper as the plaintiffs argue that the family living in the house should be protected under the Contract for Deed Act. The attorney explains that the defendants accepted payments for months while fully aware of who was living there, but are now trying to deny those rights completely. Things become more complicated once divorce proceedings and transferred ownership interests enter the discussion, turning the case into a tangled mix of family conflict and property law.
Are valid, or those arguments are valid. Again, that's a merits issue, and it likely underscores the need for this case and plaintiff's petition to be heard by this court and the underlying rights of all of the parties to be determined prior to the extraordinary remedy of evicting these people and removing them from their home. I have a note here that he cites to KSA 232707, stating that the existence of divorce proceedings is enough to invalidate the parties' agreement. But the statute merely provides that upon the filing for divorce, the property owned by the couple is subject to division, that both spouses would have an interest in that property, and that the courts may restrict transfers at that time. The statute, as far as I understand it, and I do not practice in the divorce realm, but the property, as I understand it, addresses how property is handled between spouses in a divorce. It doesn't automatically void existing contract for deed agreements or a validly assigned interest from one of the spouses to another. It may very well require the identification and sort of the adjudication of how that interest is going to be dealt with in the divorce, but I don't know that it completely invalidates. It doesn't invalidate Darren's interest, and therefore wouldn't invalidate Aaron's interest to the extent it has been assigned to him. The next argument that defendants make is that my clients have failed to demonstrate a legitimate risk of irreparable harm. Your Honor, defendants' arguments are circular in that they contend that plaintiffs cannot prove irreparable harm because they don't have a legally protected interest. But that conclusion depends on resolving the merits issues that exist before this court right now as it relates to the petition that was filed. At this stage, plaintiffs aren't necessarily required to conclusively establish their rights, only establish a likelihood of success, or at a minimum, a substantial question going to the merits. That standard is met here. There is a likelihood of success that our clients would be deemed as buyers under the Contract for Deed Act, and that an eviction proceeding against them is in direct conflict with that act and in direct conflict with what defendants' obligations were to do. And for context for this court, this should not come as a surprise to defendants because when the eviction proceedings were filed, my office, and we were retained, my office immediately reached out and said, whoa, I think you're mistaken what the situation is here. There's like a validly existing contract for deed. There's a whole statutory scheme that tells us what we have to do. It's a foreclosure, not necessarily an eviction. Defendants declined to necessarily either halt or hold the eviction process and decided, nope, we disagree, obviously based on Mr. Albin's description of why the Contract for Deed Act doesn't apply. And then they rely on this, the Kobach v. Harper case under this proposition that there is no risk of irreparable harm here because loss of possession alone isn't enough to establish irreparable harm. But I reviewed the case, the opinion that they cite to pretty extensively, and the decision doesn't address possession of a residence, nor does it hold that the loss of possession of a residence doesn't constitute irreparable harm. What it does say is that in determining whether a party shows it will suffice an irreparable future injury, the party must only demonstrate that a reasonable probability of an injury exists. The reasonable probability standard is a much lower burden than the applicable burden of proof at trial. Requiring proof of certainty of irreparable harm is too high of a standard for parties seeking injunctions. In this case, Your Honor, the plaintiffs don't merely rely on possession alone, although possession is an important piece of this, but not just possession for the sake of possession. One of the plaintiffs lives in the home with his minor child. But plaintiffs rely on the threatened loss of their rights that would exist as the ongoing purchase relationship as it exists in this case. Those facts establish, Your Honor, at a minimum that a substantial claim to rights under the Kansas Contract for Deed Act exists here. If plaintiffs are evicted, or if the eviction is allowed to proceed, and the plaintiffs are ultimately evicted, and then later prevail in this case, monetary damages alone cannot restore the possessory rights they currently hold, including the continuity of their residence, their home, and their position in the transaction. Damages also cannot adequately remedy the premature extinguishment of their rights that the Contract for Deed Act was designed to protect. So the Contract for Deed Act says, these are the type of contracts we're covering. This is the only way that you can operate under these. And further than that, the Contract for Deed Act provides that if the sellers fail to follow the very prescriptive requirements in the Contract for Deed Act, they're subject to additional penalties and things like that, which underscores the fact that it's not just about foreclosing and following the process the right way, but that failing to follow the prescription under the Statute for Deed Act creates significant harm to the people who are otherwise operating under that act and attempting to protect their interests. Defendants also argue that public interest does not favor granting injunctive relief here. Obviously, Your Honor, I would disagree. I think that the public interest is directly reflected in the Kansas Contract for Deed Act, which was enacted to regulate seller-financed real estate transactions and to prevent the forfeiture of buyers' rights through proceedings exactly like this one. I would submit to the court that public interest favors preventing wrongful foreclosure more than it favors the idea that defendants are entitled to possession of a piece of real estate that they haven't been in possession in, that they've accepted substantial payments towards, and have otherwise acknowledged in written documents and text messages exchanged between the parties and sort of all of these experiences that this has and always has been contemplated as a contract for deed. Preserving possession temporarily while we determine the underlying rights of the party does not determine ultimate ownership. It just ensures that ownership is determined through the proper legal framework. So in conclusion, Your Honor, our position is that defendants spelled out the framework, which we would agree to, or would agree is correct, that the specific elements have to support injunctive relief. Your Honor, that we would submit to you that plaintiffs have demonstrated a substantial likelihood of success on the merits, at least as it relates to this entire relationship falling under the Contract for Deed Act, that plaintiffs face irreparable harm, not just from the loss of possession, but from the extinguishment of their statutory and equitable rights tied to an ongoing purchase agreement, that there's no adequate remedy in law as monetary damages alone cannot restore possession or undo my client's rights or the impact that it would have on them as it relates to having to completely move out of a piece of property where they're living. The balance of equities favor preserving the status quo. Plaintiffs remain in possession. Defendants suffer no comparable harm from temporary pause. None that I can identify. At the eviction hearing, their position was that they are entitled to repossess because it's theirs. But the Contract for Deed Act would disagree. And the public interest is served by ensuring that the statutory framework governing these contract for deed transactions is applied before a party is allowed to be removed from the premises through an eviction proceeding. Your Honor, at the core of this, we would submit to you that this case is not appropriately formed under an eviction proceeding, which is why we brought the case as a civil action. And for those reasons, we would respectfully request that our preliminary injunction be granted. Thank you.
Very well, Ms. Linskog. Mr. Albin, I noticed that during Ms. Linskog's presentation before the court, you were smiling quite a bit. I don't know if you were particularly entertained, but this court doesn't see anything funny or entertaining about the situation currently before the court. But I do trust that you have some sort of serious response that you wish to give the court. Is that true?
That's correct, Your Honor. Your Honor, the plaintiffs are asking for an extraordinary relief based on a theory that does not match the facts or Kansas law. There's no executed contract for deed. There's no substantial.
Let me just interrupt, Mr. Albin. If we don't have a contract for deed situation here, what do your clients think is in place?
We have a failed real estate transaction. If you look at the exhibits that were produced as part of this petition, there's a purchase for sale contract, a contract amendment, financing terms, and a catch-up transfer agreement where there's only one page without any signature. We don't have any receipts for payments. We don't have any payment structure. We don't have any of those things that even under a normal contract for deed or even any other type of foreclosure defense that we would actually see where we would bring up, well, these are the substantial performance. I think that we've lost sight in that argument of what the basis of this is. It's a preliminary injunction. which before anything can be done has to presuppose the likelihood of success on its merits. We have no binding contract where there's multiple drafts that deal with negotiations. The contract law states specifically that that is not a binding contract and you can't be bound by those negotiations. That is the King versus Winger case. We have a divorce proceedings, which 2707 doesn't just talk about it, but it allows and does not allow unilateral transfer of property rights without court approval during a divorce settlement. We have Darren Budarakis, who has transferred rights to another person, which we don't actually have an agreement for, we don't know about. We have Don Budarakis, which is, for all intents and purposes, agreed that, yeah, this contract, this property isn't in the process with Darren and Don.
This section completely shifts momentum inside the courtroom. The plaintiffs warn that evicting the family would cause irreversible harm, especially because a child is living in the home. But then the defense fires back hard, claiming there was never a valid contract at all and calling the entire situation a failed real estate transaction. The judge starts pressing both sides with sharp questions, exposing major contradictions and forcing the defense to explain why payments were accepted for so long.
We have a time and an equitable ownership question, but we don't have any statements of clear payments. We don't have any improvements which are required. We don't have a defined structure, which is also required. We keep on going back to the Contract for Deed Act, but the act itself only establishes rights. It doesn't change the legal framework that we've had for over 100 years.
It establishes rights.
It establishes
rights that may not have been clearly established before, does it not?
Well, it establishes rights, but what it does is it gives more of an equitable fighting remedy more than it does change the legal framework of what a contract for deed is. It clearly defines what the legal standard has always been. And so we use the cases, the case law that hasn't changed, hasn't been challenged for over 100 years with Peterson case, the Lewis case. Those cases are well-established cases that have been used time and time again. When under Kansas law, when performance is minimal or unclear, eviction is a proper mechanism to retain possessory rights. Aaron here specifically doesn't have standings. He's not a party to the original contract. There's no valid assignment that has been presented as evidence, and divorce prevents unilateral transfer.
Okay, Mr. Albin, do you handle foreclosure proceedings?
I do.
You prosecute foreclosure proceedings?
I do.
If you were filing a foreclosure proceeding on behalf of a lender, would you name a tenant that you knew that occupied the premises as a party defendant?
I would name them as an unknown occupied tenant and any other persons that might be in the house.
Therefore, recognizing that a mere occupant of the premises might have standing in a foreclosure case.
They might have assignable transfer rights that would be rebuttable at best.
Okay, is there anything in any of the contractual documents which do exist in this case, which you say failed, that required Don and Darren to personally occupy the premises?
No.
Why wouldn't they then have the right to transfer occupancy under whatever circumstances they felt were appropriate to a third party?
They would together, but not Darren alone, Your Honor. The divorce proceedings, which were filed in 2023, would prevent that by law.
So wouldn't it be Dawn that would have a legal claim here of impropriety rather than the sellers in this case?
I think that Dawn would have her own individual rights that she could insert, but at this point, the owners of the property can argue that if it's a legal impossibility for Aaron to have standing based upon an inability to have an assignable transfer right, then at that point in time, we assert what we understand to be the actual legal consequences here, which is not a contract for deed, but a rental situation where we will maintain that we haven't received proper payment for.
Okay. And I trust that you have a lease to back up your claim that this is a rental.
We wouldn't have the lease. The lease would be with Mr. Darren Budarakis, which we haven't been presented with at this time, because it would be he who would have those rights to be able to establish.
Does your clients recognize that there was a $40,000 down payment made?
They recognize that Darren's mother made a payment, which has been returned, and there's a receipt provided.
Okay. Has that money been returned?
Yes.
Okay. Ms. Linskog, do you acknowledge that point?
No, Your Honor. I was unaware of any return or receipt. Mr. Albin hasn't provided any of that to me, and I don't know that my clients have gotten that. The $40,000 was paid on behalf of Darren and Dawn through the sale of another home that they own directly to Costa Budarakis. My most recent conversations with both of those individuals has indicated that the $40,000 was paid in cash. They don't know where or why it hasn't otherwise been applied.
You say
in conversations
cash,
with
are you literally talking about currency that was provided?
cash. Mm-hmm.
Okay.
Well, I'll get to my other question later, but no, I don't know anything about the return of a $40,000 payment.
Okay. Because you've asserted that, as one of your points, that that the sellers in this case have accepted a $40,000 down payment.
Yes, Your Honor. In March of 2025, the purchase price was reduced by $40,000 as $40,000 was paid in cash. There was also significant text messages exchanged between the parties, which I didn't necessarily want to attach the petition, but I'm happy to share or otherwise provide to the court that Mr. Albin also has access to, that these individuals have repeatedly acknowledged the transfer of title. These individuals have repeatedly acknowledged, yes, we're just going to get paid up and we're going to get you the deed, over and over and over again. So it's a little surprising to me now to hear that the $40,000 was returned, because I didn't even know that was a part of the plan.
Can you say it was Dawn's mother that provided this?
I believe so. I believe that Dawn, Darren, and her mother owned a piece of property together. That property was sold. And so Dawn's mother, I believe, had provided Darren and Dawn's share of that to the Budarakises, or to Costa directly. And then, to the extent it is helpful, Your Honor, I do have, I was able to procure for my clients proof of every payment that has been made from March of 2025 to, I can find the most recent one.
By my understanding, there was an agreement that there would be $1,850 a month paid. Correct?
That's correct, Your Honor. Most of the payments have been paid to Braxton Byfield via like a Cash App. All of the payments have in them for like this payment says for March 2026 mortgage, and they have the real estate identified. For April 2026 mortgage, that payment was successfully accepted by Braxton Byfield, $1,895. September of 2025 for mortgage. So there's considerable history here where these payments have been made up and into current, or have been made current. There is no default under the existing contract. One of the questions that I have is sort of how we get around the real estate purchase agreement that it says it's an owner carry, which means a seller financed. It's an owner carry. Line 35 says it's owner carry. So the owner's carrying the financing at a defined term of 28 years at a 4.765 interest rate. Payments have been made under that owner carry for this entire year while my clients have been in possession of the real estate. I'm not sure how we get to this is a failed real estate transaction.
All right. I'll ask Mr. Alban about that, but I have some questions about
Sorry. Yes, Your
for
Honor.
you first, some
I'll be
rather
quiet.
basic ones. One is, let's identify the eviction case number.
Sorry, Your Honor, I muted myself. Let me pull that up.
And then can you identify the attorney that's handling that?
It is being handled by Shannon Braun at Morris Lang, Your Honor, right? Morris
It's
Lang.
by
Josh?
Shannon Kelly for Shannon Kelly Law Offices.
Just ignore me. It's Shannon Kelly, my fault. Yes, Your Honor, the case number is Slab Estates LLC versus Aaron Budarakis et al. It's 2026 LM 427.
Thank you. And then you referred numerous times during your presentation, Ms. Linskog, about both defendants. Are you talking about the non-corporate defendants when you're referring to both defendants and leaving out Slab Estates LLC?
No, I likely misspoke that I meant all defendants. I think the problem that we have here and the reason that they're named personally is because a lot of these payments that were made under the contract for deed, like the cash payment and these cash out payments, they're made to Costa or Braxton individually. They're not made, that's who's accepting the payments. And we don't have an accounting from the LLC specifically about whether it received those payments or how those payments were applied to the outstanding balance or any of those things. And the correspondence between the parties sort of flips back and forth between Costa and Braxton. So when I refer to defendants, I refer to them collectively as a whole because I don't have enough clarity right now to understand who is wearing what hat when sort of all of this was happening. What I do know is that Costa or that Slab Estates is the record title holder to the real estate. There is a mortgage on the property, Your Honor, a VA loan by a third party that I also don't truly understand what's going on there. I know VA loans are really particular, which is another question we have under our violation of the Contract for Deed Act. But I just wanted to give you clarity under sort of how we sort of looped all three of those in.
All right. Mr. Alban, I promised I'd get back with you. You may make further presentation to the court at this time.
Your Honor, the only other thing that I would say is that there was no closing in this case. They never finished a closing to complete the contract for purchase contract.
What have closing entailed?
Well, closing would have entailed basic things such as deed transfer and things like that. That's what I believe.
If they were holding the deed, they wouldn't be transferring title.
Well, what was originally supposed to happen here is they were going to hold financing in the sellers and that the new buyers were going to get additional financing at some point in time. That was the contemplated negotiations that went on in this case, is that they were holding financing and so they could obtain additional financing at someplace else. That way they could fulfill the VA loan that was put on the house, have the house sold, and they can move on. Slab Estates is not in the business necessary of doing a contract for deed. That's not what their business is. They take houses, they flip them, they restore. Costa is a contractor specifically. Braxton's a real estate agent, and that's what they do is they buy houses that need work, they redo them, and they sell them. Doing a contract for deed in their minds is not what they're made for because they can't handle on that type of financing terms a 28-year term at a set rate because number one, they don't know how to do an amortization schedule to be able to handle it properly. They don't know how to do any type of interest issues that may pop up. They don't know how to do property taxes.
Things become chaotic once the discussion turns to the mysterious $40,000 payment. One side claims the money was returned, while the other side says they never even knew that happened. The courtroom then dives into payment records, cash app transactions, and monthly payments labeled as mortgage, making the situation look far more complicated than a simple eviction case. Even the judge calls the payment system bizarre, while questioning why money kept changing hands if there was supposedly no deal.
Through a buyer's finance, that's not what their business is here. The negotiations in this were they were going to obtain different financing, and that's why there was the directed seller financing at this point in time, because they were supposed to get additional financing at another place. I believe the big issue that came down in this case and why this real estate transaction failed, from my understanding of talking to my clients, is that Dawn and Darren couldn't agree about how to handle this, and that Darren didn't want to take it on by himself, or that Dawn didn't want to take it on by herself, and that we have now ended up in the process of where we are now. Is that we have a house that has somebody living in it that we didn't agree to live there. From my understanding, they haven't been making payments. And when you have somebody who's not making payments living in a property that you own, that there's no completed contract for anything, is that you try to evict them and you sell the house to somebody else.
Your Honor.
Ms. Linskog?
Both Darren and Aaron Budarakis are here. To the extent the court would like to take testimony on whether or not payments have been made and are current up through April of 2026 or not, I just want to give the court the option, because I think Mr. Albin is misinformed as it relates to those payments.
You're representing to the court that all payments that would have been due under the contract, which you believe is enforceable, have been made and are current as of today.
Yes, Your Honor, that is my understanding.
Well, given the rather unusual and chaotic method that these payments have been made, certainly I can understand why some people may not be aware of what's been paid and what hasn't. Apparently there wasn't even consistency as to who the recipient of the payments were, which I find to be not only unusual, but somewhat bizarre. But nevertheless,
sorry, Your Honor.
Ms. Linskog, you've made an assertion to the court that at this moment I'm going to take it at face value, which begs the question, Mr. Albin, if there was no deal, why were a series of payments accepted by at least some of the defendants, or perhaps all of the defendants at different times? Why did they accept these payments?
From my understanding, Your Honor, and it's that it acted more as an option contract to keep the contract alive until a closing could happen.
Under that theory, Your Honor, my clients would still have the right to close under the contract for deed, since all payments are current, and the terms would be continuing and evicting Mr. Aaron Budarakis, who is there by consent of the buyers of the real estate, would effectively negate even under Mr. Albin's version of events, would negate that ability and that right to do so.
Mr. Albin, your response to that?
Your Honor, if that's the position of the plaintiffs at this point in time, when I file my answer in this, I'll just ask for a specific performance and we'll sell the house and be done with it. I mean, if these parties are able and willing to finish this contract and to buy this property, then we don't have any harm at that point in time other than the legal costs, and that's just part of the cost of doing business at this point. My argument would be is if she believes that they still have an option open and that they are working towards a closing and a resolution of the contract, then we would allow the court, or would ask the court, to set a specific date for specific performance to happen.
Are you talking about doing a formal closing with them obtaining third-party financing, having a mortgage through the third-party financer, and essentially getting your clients out of it?
Absolutely, Your Honor.
Right. Ms. Linskog, your response to what appears to be one possible way this matter could end?
Yes, Your Honor, in that exact scenario was proposed to the defendants prior to the eviction hearing, and they declined to engage with me whatsoever on that particular issue. I had to go and argue where my clients were called squatters and otherwise sort of said they have no rights and they need to get out of here. I asked that the case be stayed. They refused to stay the case. I had to seek injunctive relief. I had to file an action here. My clients had to pay for all of that. And while I understand Mr. Albin's perspective, oh, well, legal fees are a cost of doing business. Well, unfortunately for his clients in the Contract for Deed Act, legal fees in this case are not a cost of doing business. They're a penalty for violating the Contract for Deed Act in the first place. So while I do think that my clients are wholly prepared to get third-party financing to get away from sort of this overarching leverage sort of situation the defendants are engaged in, I don't necessarily think that means that that Mr. Albin and his clients can wash their hands of the conduct they've already engaged in. This conversation that's currently happening would have been ideal to happen before we got this far down the road. That being said, to the extent that Mr. Albin is agreeing that yes, your injunctive relief is appropriate, we will stay or withdraw any eviction proceedings. I think a withdrawal and dismissal is likely more appropriate than a mere stay, and saying it will grant you X amount of time to come up with the financing in order to have this transaction closed, then we would certainly engage in that with him to avoid protracted litigation. I just don't want to give the impression that sort of absolves him or his clients from any liability in the way that this conduct was handled in advance.
Okay, Ms. Linskog, you've not only placed words in Mr. Albin's mouth, it's more than mere words, it's several important paragraphs.
I have a tendency to do that, Your Honor. I apologize, Mr. Albin.
No offense taken.
So she did make a suggestion as to what she thought you might be saying here. How much of it are you saying?
Your Honor, I could agree to a stay. A withdrawal and dismissal is a little bit of an extraordinary thing. We still need to have a date certain for specific performance to hold toes to the fire. That's part of the issue here, is the continuing, the pushing, we want to finish this, and we just never have got resolution.
Okay.
I would just.
Any last words, Ms. Linskog, with an emphasis on last?
Yes, Your Honor. The fewest words I've ever attempted to add. I would argue the defendants cite a 28-year contract for deed. I understand they want it faster. I'm not suggesting my clients can't get it faster, but they're not entitled to specific performance until they plead it and otherwise identify that they are entitled to a faster performance than the contract for deed initially identified here. I'm not suggesting that it won't happen, just merely that they're not currently entitled to that kind of remedy.
Very well. Court will decide the matter which is currently before it. The court does find that each tract of real estate is by its nature unique. When a potential buyer, like we have in this case, is deprived of an interest, and interest could extend to as far as, in Aaron's case, an occupancy interest, that it merits protection. Court finds that the plaintiffs have shown that they have a substantial likelihood of proceeding and winning on the merits, that there is no adequate remedy at law that would substitute for the injunctive relief which is being sought, and that they would suffer irreparable harm if they were evicted from the premises prematurely until this matter was sorted out. This court will grant the motion for a preliminary injunction in this case, to the extent that it places a stay on further prosecution of 2026 LM 427 in the Butler County District Court. The court obviously will not dismiss that. And the court certainly understands Mr. Albin's position that if anything, that proceeding is stayed and not dismissed. Ms. Linskog, before I forget, I think what you're going to need to do is you're going to need to draft the preliminary injunction order, submit that to the court, and then file with a cover sheet in the limited case, a copy of that order in the limited action. which was probably your intent anyway. But I want to make sure that file reflects the stay that's been granted in this case. I'll also point out to the parties that Judge Murfin is no longer serving as the limited actions judge, that there would be a different judge that would be hearing the case in the future. But that said, that case has stayed anyway. I encourage the parties to kind of build on the foundation that was laid late in today's proceeding about there is a way perhaps in which the contract can be finalized by third-party financing and more traditional handling of a real estate sales, regardless of who the buyer might be. I think under the contract, it would be Darren and Dawn. And obviously, there's going to need to be some cooperation between the two of them. The court will preserve the occupancy rights of Aaron Budarakis and his family at this time, as it doesn't appear that Darren or Dawn are challenging their current occupancy. All right, Ms. Linscock, with the injunction granted, was there other relief sought under your request for injunctive relief, which the court has not yet addressed?
Your Honor, the only open item as it relates to our motion for injunctive relief is just clarity as it relates to the ongoing payments under the contract for deed. My clients are happy to pay them into escrow. They're happy to not pay them if that's the court's order until further determination is made. They are, whatever the court's order is there. I just think we need clarity on how moving forward and whom they should be paid to. Historically, they've been directed differently. So that's the only clarifying piece.
I will address that. Now, when is the next payment due?
May 1st, I believe.
All right. The court will not require a bond in this case. Rather, security is insured by this court will require the plaintiffs in this case to make the $1,850 per month payments to Ms. Linscock's client trust account, with her to hold those payments until further order of the court. That way, with those payments being made systematically as these proceedings continue, the money is there to be turned over to the proper party if deemed to be appropriate by the court later. The court has no intention of granting any request for relief to stop payments, but Ms. Linscock will have the responsibility of monitoring those. Furthermore, the court will require a report each month when these payments are made as to the following information: the date that the payments were actually made to Ms. Linscock, the amount that was paid, the form of payment, and the court will require your office, Ms. Linscock, to report to Mr. Albin within 5 business days of any such payment being made. It can be done by email as far as the court is concerned. But I want them to be aware that these payments are indeed being made and have been received by your office and in what form those payments were made.
Yes, Your Honor.
All right. Any questions about that, Mr. Albin?
No, Your Honor.
All right. And of course, I'll expect that with the very next installment in May. If you could include some of this in the order which grants this preliminary injunction, Ms. Linscock.
I will do so, Your Honor.
Okay. And I would highly suggest the parties, again, work on the option that was discussed late in today's proceeding about third-party financing and formal closure of matters involving this real estate tract.
Yes, Your Honor.
All right. Mr. Albin, is there anything further from your perspective that we need to address at this time?
No, Your Honor.
Ms. Linscock?
Nothing from me, Your Honor.
Very well. And if there's nothing further, this matter will currently be in recess at this time. This meeting may be ended for all parties.
Thank you, Judge.
In the final part, the case suddenly takes a dramatic turn when the defense suggests they may actually be willing to complete the home sale through proper financing. But the plaintiffs argue this conversation should have happened long before the eviction fight started. After hearing both sides, the judge ultimately grants the injunction, allowing the family to stay in the home while the legal battle continues. The court also orders future payments into escrow, bringing temporary stability to the dispute. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next one.